I said that I'd do a quick speed run through the content that we've covered and could be assessed in the SAC. This is really for people who are struggling to get across the key dot points that we've covered in the outcomes so far. But really the best way to prepare for this SAC is to complete practice questions, to mark those practice questions. So without further ado, however, I'm going to show you how to get to this document, the term planner that has all of the links to our COGs. So essentially, if you're on Google Classroom, hello, go to classwork, boost down to planners and timelines, open this up, boop, 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 and it will go to this document here. So this has got our lesson by lesson breakdown of what we've covered and links to all of the COG sites. So of course, when we come to the principles of justice, we've got fairness, equality, access. You need to know what these mean, but you specifically need to know what they mean in the criminal justice system. So remember, when we're talking about fairness, we're talking about processes, procedures, those things that make the justice system fair. It's really hard to, there's no good synonym for it, but they're things that increase, say, procedural fairness, so the actual processes themselves are transparent, that and that both accused people, victims, are able to see what's going on in the lead up to their case. I mean, the seeing what's going on also links to access. Fairness and access are linked really explicitly, but we've of course got equality, which means people receiving equal treatment before the law, so treatment that is the same irrespective of their personal characteristics. And then we've got access, which is about particularly about an accused person being able to understand the case against them and also defend that case and have access to the resources, or be able to get the resources and the legal knowledge and the assistance they need to pursue that. So that's the principles of justice here. If you click on this and you go to the site, it will take you to the page, the COGS page, that has all of the pre-work lessons, as well as an absolute plethora of supplementary materials that you might want to access and points about where you want to go in your textbook. Okay. We've got summary and indictable offences. All right, we know what's happening with those. Summary offences, minor offences that are heard in the Magistrates Court, indictable, more serious offences that are tried in the county and Supreme Courts, unless they are part of that appendix in the Criminal Procedure Act that says that there is an option for them to be heard in the style of a summary offence in the Magistrates Court. But remember that a magistrate needs to, the accused person needs to apply for that to happen, and the magistrate needs to approve this for that to go ahead. It is not an automatic category of offence. It might be a strategic move by the Defence Counsel because, of course, we know that in the Magistrates Court there are much lower minimum sentences, etc. Okay, so we've also got key concepts in the justice system, and I think that my movie has cucked it, so I'm just going to get rid of that, and maybe we can start a new one, but here we go. Because otherwise you won't listen to me. Here we go. All right, then we've got key concepts in the justice system, and we've got a lot of different sub-dot points under this, okay? The standard of proof, the burden of proof, the presumption of innocence. Okay, so let's have a quick hop onto the COGs here, but we've got our principles of justice slides here that you can go back to. Sorry, our legal principles, blah, blah, blah. Here we go. Okay, cool. Key concepts is what we want. All right. And we're concerned with these 4 key concepts. So standard of proof, also who are the parties to a criminal case. It's always the accused and the prosecution, although we know depending on the severity of the offence, the prosecution can be comprised of either a police prosecutor or the DPP. Burden of proof, presumption of innocence. I feel like we're pretty across these, and we've kind of stamped out that that issue with students sort of saying the standard of proof, it's like, was there a smoking gun, or did that person actually do the thing? The standard of proof is simply the amount and quality of evidence that is needed to be brought to prove a case. And in a criminal case, it is always beyond reasonable doubt, which, as we know, means that if a jury has a reasonable doubt or has a doubt and it's reasonable, they're not able to convict a person. I just talked about the parties to a prosecution in a criminal case. Burden of proof, remember, I'm always doing this. It's always that it's not a person, it's the responsibility, it's the burden to bring the evidence in a case in order to meet the standard of proof, which is beyond reasonable doubt. And of course, we've got the presumption of innocence being the key principle, or that concept in the justice system, that when a person is accused of a particular offence and they're charged with that offence, that they are presumed innocent until the party with the burden of proof manages to discharge that to the relevant standard, okay? And you can see here, if I just click through, blah, 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 there are a lot of different ways that this is burden of proof, presumption of innocence, a lot of different ways that this is protected through the system of bail. It's guaranteed in the Vic Charter of Rights and Responsibilities. The right to remain silent in proceedings and during police questioning all bolster this. The fact that prior convictions in most circumstances are not revealed until sentencing, so they're not relevant in the trial stage. The need for a committal hearing, which we will talk about in much more detail later in the outcome, but this idea that the case kind of needs to be tested first, where it's an indictable offence, before it is committed to a trial in a higher court. And a less strong point here, but the right to appeal where someone really feels that they have had a wrongful conviction also helps to support this right. Okay, so there are our key concepts. There's a lot in that. Then we get to the rights of the accused, which are multifold. So we've got a part 1 and a part 2. If you hop onto COGS, we've got it all here, but please do have a look at the supplementary readings around this. So we've got here first rights of the accused, mostly stemming from the Vic Charter of Rights and Responsibilities, but we've got the right to be tried without unreasonable delay, the right to a fair hearing, the right to trial by jury. We looked at these two first, and the right to be tried without unreasonable delay is guaranteed by the Victorian Charter of Rights and Responsibilities, and it really links in, strongly with the principle of justice, fairness, and of course access in some measures. And so it's explicitly outlined in the Vic Charter. We looked at the case study of Gray and the DPP, which is an appeal case. Have a look at that. Keep it in your toolkit to use as an illustration if you need to. The right to trial by jury, we looked at also. The constitutional source of the right to trial by jury is a bit fraught because, of course, we know that's only available in really limited cases where there is a Commonwealth indictable offence. That's not that relevant to us here in Victoria. In Victoria, where someone is charged with an indictable offence, the Criminal Procedure Act requires that a jury is impanelled, although that's not available for summary offences. So again, keep that in your toolkit in case a stimulus should arise where someone is charged with a summary offence and, they've been advised they're allowed to have a jury trial, yada, yada. Okay. Then we've, of course, got right to a fair trial, which again has two subcategories. A competent, independent and impartial court deciding the proceeding or charge, and that the hearing is fair, public and transparent. Okay, transparency linking directly into the principle of fairness. Of course, there are some exceptions to this where it's going to jeopardise where the intrusion of the public, I guess, would cause undue stress to victims in a sexual offence, where there's a sexual offence involved. This is guaranteed by the Vic Charter of Rights and Responsibilities. Wahoo! Before that, the law was pretty disorganised and it was a bunch of different common law principles. We looked at this case of Dietrich and the Queen and the idea of a fair hearing also being linked to this idea that people are able to obtain legal representation. Okay, we did a deep dive into Momcilovic as well. That was more closely linked to the presumption of innocence. All right, little summary at the end for you there. And we're hitting the home stretch, rights of the victim, okay, which we did in one big omnibus lesson, but there are, again, lots of different parts to this. So if you're looking at these, and I'm just going to quickly get this up, rights of the victim, we looked at the victim's charter, which is the source of a lot of these rights, but to give evidence as a vulnerable witness. Remember, we want witnesses to be able to give evidence to assist in a criminal to assist in the achievement of justice in a criminal proceeding. But of course, we also know that there are witnesses who may be vulnerable, okay? People who are required to give evidence in a criminal case, but they could be impressionable or at risk of further traumatization themselves, okay? So children, people with cognitive impairments, or the alleged victim of a sexual offence, all right? So that's the kind of broad umbrella with which we're looking at vulnerable witnesses and their ability to give evidence. And then there is a bunch of really granular wormholes that we went down around the kinds of things that the court's able to do to make these witnesses comfortable and to, I guess, accommodate them, okay? But lots of these only apply in certain kinds of cases, so you do need to be keeping an eye out for these. So they're particularly prevalent or available where the offending has a sexual nature, it's family violence, there's something that is, sensitive, right? So the kinds of things that you can talk that the court can provide are also listed here. Protected witnesses, again, the court's able to declare at any time a witness is protected with sexual and family violence offending. Special arrangements can be made for those under 18, cognitive impairments, etc. And also if there's assaults where there's something going on of this nature, okay? Improper questions are also able to be disallowed under the Evidence Act if they're going to unduly harass a witness. So, yeah, I guess we're really trying to home in on this. Is the victim that we're talking about or the witness that we're talking about someone who would be vulnerable, and what rights are available to them and where do these come from? All right. The second part is a little bit less complicated, and we had a look here at the right to be informed about proceedings. So you need to know the kinds of things that victims are able to be informed about under this right. That's protected by the Victims' Charter, not the Victorian Charter, mind you. Here it is. And also the right to be informed about the likely release date of the accused. Remember, that is available where a victim has applied to be on the victims register. And it is available to those people who are the victims of violent offending, some examples of which you can see here. Okay, yeah. And then they're entitled to receive particular information from the various agencies involved. Okay, so that sums up everything that we have done, and hopefully you will be able to direct your revision to the holes or the gaps in your knowledge. I will also be doing a targeted video based on our SAC, practice SAC responses as well. So please do keep an eye out for that, and don't hesitate to send me any emails should you need.